Uh, we thank you so much for watching Law School Made Easy at Law School Made Easy 256. Today, we want to go straight to constitutional law and we look at the topic supremacy of the Constitution, and that is Article 2 of the Constitution is what we want to look at and appreciate the supremacy of the Constitution. Article 2, Clause 1 suggests that the Constitution is the supreme law, the grand norm of the land, and all other authorities and persons derive their powers from this Constitution. What does this mean? As upcoming lawyers or as lawyers, you must appreciate the fact that the Constitution is the supreme law of the land. This is the law. This is what we all believe in. Now, as lawyers, you swear to protect the Constitution. That all the rights, for example, enshrined in in chapter 4 of the Constitution, all must be respected because they are the Constitution. And they are telling you that the Constitution is the supreme law of the land. It is not by mistake that Article 2 is coming where it is. That as we interpret in future, we have done videos of principles of interpreting the Constitution. They are telling you that this is the supreme law of the land. As you interpret any law, as you talk about any law, appreciate the fact that the Constitution must remain supreme. Because it is the Constitution which provides all the powers to anybody. Look at Article 126 of the Constitution, which says that, which creates the court of the judiciary. It says that the judiciary shall derive its mandate one from the people and this Constitution. And Article 1:1 is not by mistake, that all powers belong to the people. And now it is this same Constitution which is protecting the rights of all the people. So meaning that as we move forward to interpret our rights, as we move forward to do day-to-day operations in the country, we must respect the Constitution under Article 2, Clause 1. This now takes us to Article 2, Clause 2, that any law or custom that is inconsistent with the provisions of this Constitution, that other law or custom to the level of its inconsistent shall be declared void. I want us to appreciate this, that any law or custom that is inconsistent with any of the provisions of the Constitution, that custom or law shall be, to the level of its inconsistent, declared void. What do we mean? Let's go to section 20 of the Ordinary Council, which talked about the repugnance clause. You see that even in the repugnance clause, they are telling you, before we received this Constitution, they are telling you that any custom which is inconsistent with the doctrines of natural justice, consciousness, equity, that custom shall be declared repugnant to the usual norms. So you see, this is the background of this article. Let's go to the case of Tinyefuza versus Attorney General, where the retired emeritus Professor George W. Kanyamba put it clear that the Constitution is the supreme law of the land, is a grand norm. It must be respected. The moment you fail to respect any of the articles in the Constitution, you have violated that article. You have violated the Constitution. And then I was saying that under Article 25 of forced labor, maintaining seducer to operate in the army against his will was subjecting him to forced labor. Now, what is this saying? That the moment you don't leave him to leave the army, it means you are violating one of the articles in the constitution, and that means you'll be violating the constitution itself. So that is the strength of Article 2 of the constitution. Let's look at the case of Andrew Mwenda and another versus Attorney General. In this case, Mwenda was being charged of seditious citation with a colleague and seditious offense. This meant that they had talked bad things about the president. They had encroached on the peace of the president. How do they talk about anything which involves the president? Court said, no, you can't have section 39(1)A and 41(B), seditious intention and offense, in the penal code because they are violating Article 29 of the Constitution, which gives somebody freedom of speech. So if you say that the president cannot be talked about, then it becomes a challenge. So section 39 and 41A and 1B respectively were scrapped off in the penal code, being inconsistent with the provisions of the Constitution. So any law which is inconsistent. Let's look at the feeder case, the women lawyers versus Attorney General. They were contesting many provisions of the Divorce Act, including Section 4 of the Divorce Act. Remember, Section 4 provided that for you to succeed on grounds of divorce, you must prove all of them. And then 154, if you remember, in the penal code was about adultery. It would apply to the man and not to the woman. So the women lawyers were contesting this, and the court declared that where any provision of any statute is inconsistent with the Constitution, that provision will be declared null. And the same way, Section 4 of the Divorce Act was amended in the feeder case. Now, that is the strength of the Constitution, that it is supreme. This tutorial is actually made for the learning councils to appreciate the supremacy of the Constitution. Let's look at the case of Salvatore Aboki versus Attorney General. These were being charged of witchcraft. But first, the question to court was, what amounts to witchcraft? Having bead spears, back clothes in my home, does it mean I am a witchcraft? And then Section 3 of the Witchcraft Act was scrapped off because it was never clear. Remember Article 28, Principle of Legality, 28 clause 8, yes, clause 8 and 7, where the law must be clear. The law should be clear. But in this case, it was not clear on what amounts to witchcraft. And then Section 3 was scrapped off. Not stopping there. In the same case, Salvatore Aboki, they were being banned from the village. Charged, convicted for 10 years, banned from the village, and the court was saying, no, you have punished them. Again, you are sending them away from the village. But this is the village they know. This is where they grow their food from. This is where they live. This is where their home is. Now, where are you sending them? You are the same person saying, you protect life. You protect people with their property. But again, you are sending them out of their property. You are violating the Constitution. So, that is the strength of Article 2 of the Constitution. But let's continue to Article 20. Above all, as we do this, human rights are inherent No one gives them to you, are close to. The state government are supposed to protect you as you enjoy your rights given to you. First, the Constitution is acknowledging that human rights are inherent. And then in clause 2, it acknowledges that the state government are supposed to protect you as you enjoy all those rights which have been given in the Constitution. That is the strength of the Constitution. Look at provisions of making the law. Article 79(1), that the Constitution provides and says it is only Parliament supposed to make law. So no any other body that can make any law under Article 79(1). That is the supremacy of the Constitution. It has directed you, respect the rights of people. Look at 79(2). Still it tells you where any other person can make the law, they should get that mandate from Parliament. That Parliament can delegate any other body to make the laws, for as long as they are in conformity with the Constitution. So that is the supremacy of the Constitution. With all those cases that we have discussed and those few articles we have discussed under the supremacy, please endeavor to appreciate it and like it as a lawyer, because it will help you if you continue and follow and appreciate the Constitution being the grand norm and the supreme law of the land. We thank you so much for watching Law School Made Easy. At Law School Made Easy 256. Subscribe, share, like our videos. Thank you.